Very well. I have to go ahead from Bendy now. A very good morning to everybody and good evening to those who are in my part of the world. A very warm welcome to you. This seminar is a part of the two seminar series which the IBBI, which is the Indian regulator, insolvency regulator, and IIII are collaborating on. And the subject of the two is avoidance applications, as you'd have seen from the promotional material that has been circulating in the social media. But this series is something which is a part of what we are hoping to be a long-term agenda where IIII and IBBI collaborate in terms of helping the Indian market on a series of issues, in particular on education and capacity building, helping understand from the US experiences and the experiences of the other jurisdiction. And I think it's a great opportunity and a great initiative. My association with IIII goes back to 20 years, although my membership is quite recent. But of course, we'll hear a little bit more about IIII from Michael and others as we start. So moving on to the topic just for 30 seconds before I invite Dr. SAHOO to make his keynote address. This subject is of great interest to the Indian insolvency professionals, lenders, and other stakeholders. The first four and a half years that we spent on implementing the insolvency has focused on other priority issues, and we've made a tremendous amount of progress. But avoidance is one area where we believe, at least speaking for myself, it hasn't received as much of traction as I believe Dr. SAHOO would expect, and some of the players in the market thought that we ought to achieve. But I guess the time is now ripe for us to give a little bit of push in order to prioritize this suitably. And it is in that spirit that we have assembled today to sort of bring this issue under the spotlight once again. I'll leave it at that, and I'm sure we have plenty to hear from today. And at this stage, I'll request Dr. SAHOO, who is the chairperson of the Insolvency and Bankruptcy Board of India, has been one of the key champions of the implementation of the insolvency law. I would have loved to speak a little bit more about what his contributions have been, but I think it's more important to speak, hear from him. Speak on the insolvency law and what he expects from the session today. Thank you so much. Over to you, Dr. SAHOO. Dr. SAHOO, over to you. Could you please unmute yourself? Or is it there, or because this his video seems to have gone still. His picture is frozen, it seems, yes. Or maybe he's trying to reconnect again. And in the meantime, what I suggest we do in the interest of time is to start the discussion, and then we probably would go back to him once he joins again, in the interest of time, since we do have a large number of audience already in there. I was hoping that maybe the best way to start this would be to familiarize our audience, which a primary number of them I'm hoping would be from India, who would want to understand a little bit, at least scratching the surface level of how the avoidance transactional regime works in US. And that is in particular of interest because, we have the creditors and control regime, and you have the debtor imposition regime, and therefore it'll be good to have some basic understanding of how that works, and also it'll be good to also know in that process as you sort of familiarize us on that as to essentially some of the fundamental issues. Who decides whether an application should be filed or not? Who benefits from it, and what are the driving factors? And essentially, how does the process work? And also, I'll be thankful if you could also touch upon what essentially are avoidance applications under the US law. And of course, we have to unfortunately do it very, very briefly because we do have, a very limited time on our hands. So shall I request, Michael, you to start on that, please?
Very good, Sumant. Speaking for the International Insolvency Institute, my law firm, Blankrom LLP, and my fellow panelists, the distinguished Robert Feinstein of the PACHULSKI firm and the equally distinguished Maya ZERJAL FINK of Arnold and Porter, we want to thank you for the opportunity to speak with you today and to be of use to the Indian insolvency community. Each of us are experienced practitioners under the US bankruptcy law, representing different constituencies, primarily in Chapter 11 reorganization cases. Robert is very well known for his work for unsecured creditors and creditors committee mandates in these Chapter 11 cases. I do that work from time to time as well as representing senior lenders. And Maya is distinguished as a rising star within our bankruptcy practice and has done a great deal of company side work at Arnold and Porter. This morning, we hope is the beginning of an important constructive dialogue between our restructuring communities over avoidance actions and related reform, perhaps in both of our countries. We all are at your disposal to continue this dialogue after this talk. We note that there is a chat room in which you may pose questions, and Mr. BATRA will be monitoring that and acting as an interlocutor between your inquiries and us. Now, we're very aware of India's important achievement in respect of its 2016 reform of its insolvency and bankruptcy code and the specific origins of that reform, which have enhanced the functioning of India's globally important capital markets. I'm going to ground our conversation today in the policy basis for the avoiding and related powers contained in Chapter 5 of the US Bankruptcy Code. I find that understanding comparative systems of law often benefits from understanding the basic policy differences between systems of law. So that's where we're going to start. Now, before I get into it, I want to note that we are simply sharing perspectives. We're not offering criticism. Our goal is to provide you as a community with information that may help inform your thinking as practitioners and policymakers, and we hope to benefit similarly. Let's start.
Michael, sorry to interrupt. I think Dr. Sao is back, and if you don't mind, can we get a mic to him for his keynote address? I'm sorry for interrupting you, but
very good.
I'm extremely sorry for the problem from a technology side. Thank you, Mr. BATRA. And thank you, my friends from overseas, Mr. FEINSTEIN, Ms. FINK, Mr. SCHAEDLE, Ms. Graham, and my dear IPs and IBBI colleagues. Welcome you to this webinar. I'm extremely grateful to International Insolvency Institute for this initiative to build the capacity of handling insolvency profession in India on a very important dimension of insolvency risk. This is about dealing with avoidance transactions, which has not gained much traction in India, as Mr. BATRA told, but we probably cannot avoid it any longer. We need to deal with avoidance transactions in a manner that promotes the primary objective of our insolvency law. It serves our insolvency law in many ways. Let me just elaborate one or two, three such ways. First, the insolvency law enables the stakeholders to avoid vulnerable transactions, that is to undo them. Where value has been lost on account of such transactions, the law enables clawback of such value. If such transactions are undone, the lost value is retrieved the creditors stand to realize value from vulnerable transactions as well as from the existing assets. Consequently, the value of the corporate in distress goes up. Higher the value available with the corporates in stress, the higher is the likelihood of a resolution of stress by a resolution plan, which is the primary objective of the insolvency law. Second, an avoidance transaction, if it can be avoided, the gain to the beneficiary can be undone, and the beneficiary of such transaction can be required to disgorge the gain. The insolvency law thereby takes away the incentive to indulge in such transactions. Since such transactions are considered criminal in certain circumstances, particularly when it is fraudulent, this also disincentivizes a potential miscreant to indulge in vulnerable transactions. Such incentives and disincentives are likely to ensure that there is no vulnerable transaction, and in that case, no value will be lost. If the value remains with the company, the possibility of a company getting into stress is much less. In this sense, the insolvency law proactively prevents stress. Third, the law usually mandates retrieval of value lost due to the failure to exercise due diligence. This finds place in Indian law in section 66, subsection 2 of the code, which makes the directors liable for the loss to the creditors that arise when the resolution process should have commenced, that arises between the time when the resolution process should have commenced and when it actually commenced. So there's a twilight zone which begins from the time when a director knew or ought to have known that there is no reasonable prospect of avoiding the commencement of a resolution process, or till the company enters the resolution process. During this period, a director has an additional responsibility to exercise the due diligence to minimize potential loss to the creditors, and he is liable to make good such loss. This incentivizes the corporate as well as its promoters and managers to seek resolution in the early days of the stress when the possibility of a resolution is higher. Generally, when vulnerable transaction is avoided, the underlying property returns from the beneficiary to the corporate debtor. The beneficiary gives up the property. But section 66(2) is, however, a quite different provision as compared to other vulnerable transactions. It provides recourse against the director who made the transaction and not the beneficiary. This provision has actually, probably very rarely, it has been used, I would say underused. But if this is effectively used, we would not see the resistance from companies or their management at the time of admission to initiate CIRP. And in the process, the admission would be much faster. I would request my IP friends to make a point in every CIRP to assess the loss to creditors in this twilight period and file applications under section 66(2). And if they do this, this will take away the entire incentive of the promoters to resist admission and enable commencement of a resolution process when chances of a resolution are very high. So for the success of any insolvency regime, it is critical that distressed companies are prevented from taking measures which could hamper a recovery to creditors in the run up to the insolvency proceeding. And such protective provisions assume particular importance in Indian context, where we have seen some companies, or maybe majority of the companies in Indian context, are often closely held by promoter groups who may seek to transfer value from assets to OPEX structures for their own benefit. Therefore, the Indian law empowers the adjudicating authority to undo any such transaction to protect the interests of creditors and other stakeholders. It undoes these transactions based on an application by an insolvency professional, either as a resolution professional or liquidator. In fact, the entire onus is on the profession of insolvency professionals. Sections 43, 45, 50, 66, all these mandate the RP and liquidator to file in applications in respect of avoidance transactions. By avoidance transactions, we have listed out preferential transactions, undervalued transactions, extortionate transactions, and fraudulent trading. With the applications are to be filed with the adjudicating authority seeking the appropriate reliefs and directions. And section 47 of the code, in fact, provides that where an IP has not done it, the adjudicating authority shall require the IBBI to initiate a disciplinary proceeding against the RP or the liquidator, as the case may be, where he has failed to report undervalued transactions, particularly to the adjudicating authority. So I am only trying to emphasize the role an IP can play. Earlier I told that if you file the application on 66.2, we would not see any resistance to admission of applications. And if you do not do, there can be the disciplinary actions against you, and the adjudicating authority can refer the matter to IBBI. In fact, keeping these provisions and importance of the provisions in view, the IBBI regulations mandate that an RP, say, let's say the CIRP, an RP is required to form an opinion whether the corporate debtor has been subjected to any avoidance transactions. He has to do it before 75th day of insolvency commencement date. And where he has taken a view that as it has been subjected, he shall make a determination before 150th day of the commencement. And that he will do under intimation to the IBBI. And he shall apply to the adjudicating authority for appropriate relief within 135th day of the insolvency commencement date. We have seen a few cases. There are instances where some IPs do not adhere to this timeline. They don't discharge this responsibility with full responsibility. In a recent matter, Santosh Choraria, that is the RP of Suraj Fabrics Industries Limited versus Bipin Kumar Bhora. The adjudicating authority was so unhappy, it observed that in this case, the RP filed an application on 389th day of the CIRP commencement. And he filed an application. After he filed the application for approval of resolution plan, he did not make any determination. He relied solely on the forensic auditor's report and did not give any independent reasons for determination of preferential transactions. The adjudicating authority observed there actually. It's observed that the feeling the adjudicating authority got, it observed that the feeling is inescapable that the resolution professional has filed the application under section 43, read section 44, only to avoid adverse scrutiny on the part of the IBBI and not with any real intention to pursue the alleged preferential transactions to their logical end. We would not like this kind of observations from the adjudicating authority in respect of any insolvency professional. And if it happens, IBBI has no option but to be asked in such cases. The Supreme Court has clarified the role of an insolvency professional, the landmark judgment. The Supreme Court didn't have the opportunity to deal with many such cases. Supreme Court has dealt many other aspects of the insolvency law, but on these avoidance transactions in the matter of Anuj Jain versus Axis Bank Limited, it clarified the duties and responsibilities of RP in respect to avoidance transactions. It has given a step-by-step that shift through all transactions related to property, identify whether it is a related party or not, etc. And then says that, then look at, examine every transaction in each of this category to find out whether it is a transfer of property or interest in it, and beneficiary involved stands in the capacity of a creditor, guarantor, or surety, and then goes on to say ultimately that you must apply to the adjudicating authority for necessary orders. After carrying out, the Supreme Court uses the word volumetric and gravimetric analysis of the transactions. IBBI has come out with some facilitation also. It has come out with some, the red flag, we call it a red flag document, which should alert an IP if he finds these kinds of situations, it alerts him that there is some possible avoidance transactions. Please look into this. But the area is yet to settle. Recently, there has been an order from the Delhi High Court, that is in the matter of Venus Recruiters Private Limited versus Union of India. Their High Court has made some observations that has created some issues. It has raised some issues. I think if the matter is on appeal, it has held that the avoidance transactions, avoidance applications does not survive beyond the conclusion of the CIRP. It is meant to give the benefit to the creditors and not to the creditor, not to the corporate debtor subsequent to its resolution after the approval of the resolution plan. And therefore, before the creditors part away from the corporate debtor, they must get their dues and it must conclude. This actually tells the basic spirit of the law, that everything must be completed in a time-bound manner, and that is why the applications have to be filed within the specified time. And it says that the adjudicating authority has no jurisdiction to entertain and decide avoidance transaction applications in respect of a corporate debtor which is no more under CIRP, which is now under the management, new management after the approval of resolution plan. And the RP cannot continue to act on behalf of the corporate debtor with the title like former resolution professional once the plan is available. But I am sure this issue and many other issues which will arise from practice and will go to high courts and Supreme Courts, things will be settled. But we have to file the applications and detect these transactions, then only the matters will attain the finality. There are several issues. I am sure both IBBI, IPs are confronting. We look forward to hearing from our eminent speakers. We have several issues like supposing if IP does not determine and file an application, how does IBBI or a third person know that that company had been subject to vulnerable transaction and the insolvency professional did not do his duty? And then, like in the case I referred to, where NCLT told that he did not apply mind, is it necessary that IP must be competent enough, or he himself has to determine the transactions, or can he use the services of any other professional? And if so, who is that professional who can detect these avoidance transactions which can stand this scrutiny of law? And while the applications that have been filed are yet to be disposed of, if the things do not fall in line the way the Delhi High Court has expected, everything is closed by the time resolution plan is approved. If these applications remain thereafter, so what would happen to the underlying value of the transaction value underlying these transactions? Can these values or the applications having underlying values can be sold and traded in the market? Can somebody else take over and pursue it? We do not know what would be the answer. And even if it happens, let's say that the resolution plan is approved, this application continues before the adjudicating authority. So who would ultimately be the beneficiary of this value, whether it's corporate debtor or creditors? I'm sure we will have some answers to some of these questions, and many more questions the IPs have in their mind in respect of avoidance transactions. We are lucky to have the most experienced professionals from the mature jurisdictions. So I thank Mr. FEINSTEIN, Mr. FINK, and Mr. SCHAEDLE, and of course my friend Mr. BATRA, who are here to guide us on these transactions. And I thank them for sparing their time to talk to us, and I look forward to hearing them. Thank you.
Thank you so much, Dr. SAHOO. And as you were speaking, a number of questions that are coming in from the participants, and many of them, of course, raise similar issues as you also articulated. And I would also, try to sort of, during the panel discussion, see to what extent we can cover them, so long as the US jurisdiction would be able to throw any light on that. So I will go back to you, Michael, from where you left. Please feel free to continue. I know that you were just providing a backdrop of the context, and feel free to pick up from there. Please.
Very good. Thank you, Dr. SAHOO. Those comments were a great framework for our discussion today. And again, thank you, SUMANT, for all of your efforts in organizing this. As SUMANT indicated, I'm going to ground our conversation in the policy basis for the avoiding and related powers contained in Chapter 5 of the U.S. Bankruptcy Code. And I think you start at the beginning. You know, the U.S. Bankruptcy Law is a reaction to English insolvency law and creditors' rights law. Dickens teaches us that it was quite punitive. And as a young lawyer, I'd often walk past the site of a debtor's prison on Walnut Street in Philadelphia, where I live. That's the place where George Mason was imprisoned for debt. And he, of course, financed the American Revolution. So it's no accident that our Constitution empowers the U.S. Congress to enact uniform bankruptcy laws. In other words, bankruptcy laws that preempt the original requirements and rules of our states and our federal system. And throughout the 19th century, Congress would exercise that power situationally. A recession or a depression would occur, and a bankruptcy law would be enacted that would sunset after a number of years. Generally, the jurisprudence that grew up around these laws was that the primary purpose was to provide individuals with a fresh start and businesses with relief from a race of diligence among creditors under state law. And finally, to enforce equality of distribution amongst creditors. Progressively, it became apparent to U.S. practitioners and professionals that sunsetting bankruptcy laws were ineffective to provide the relief necessary for the growing engine of American industry. And so in 1898, a permanent bankruptcy law, the first permanent bankruptcy law, was enacted, the Bankruptcy Act. And at its heart were those policy purposes. And the Supreme Court in jurisprudence thereafter specified that all decisions relating to the American bankruptcy law should hold those policy goals as preeminent. And again, they have been coupled with what the Supreme Court in Adair versus Bank of America National Trust and Savings Association back in 1938 characterized as the, quote, progressive liberalization of bankruptcy and insolvency laws in an effort to avert the evils of corporate liquidation and to favor corporate reorganization and rehabilitation. That progressive liberalization led to our present law, the Bankruptcy Code, which was enacted in 1978. And that law, as SUMANT mentioned in his opening remarks, is to some extent debtor-centric. It leaves management in charge of the ordinary decisions of the business, while providing a debtor with an exclusive right in Chapter 11 to reorganize under a plan of its own design. These powers and prerogatives are countered by the creation of a variety of rights and tools that protect creditors, including secured creditors and unsecured creditors. But it's important to understand that the American bankruptcy law, at its essence, is about creating a value maximizing collective remedy that is designed to serve the social purpose of keeping businesses and technologies in the stream of commerce. And so this is somewhat different than the very important policy purposes animating the Indian insolvency and bankruptcy law that has just been enacted. The Indian law, as we see here in the United States, is a highly performing, smartly designed creditor-supervised collective remedy that is intended to benefit senior creditors, creditors which have had their property rights and collateral impaired by the practical and formal operation of prior law. This basic difference informs how avoidance powers are treated in each of our systems of law. U.S. avoidance powers are found in Chapter 5 of the U.S. Bankruptcy Code, and in the part of that chapter that defines the bankruptcy estate, subchapter 3. What the creation of the estate is about is finding a maximal definition of a debtor's interest in property to help create, if you will, a bankruptcy balance sheet that enables residual risk takers in a debtor, like general unsecured creditors usually, to have generally equal distributional rights in a reorganization or a liquidation, and hopefully in an enhanced estate. So the avoiding powers, therefore, upset secret, unperfected liens and encumbrances under state law. They give a bankruptcy trustee, including a debtor in possession and a Chapter 11 reorganization, the rights of a perfected judgment creditor under state law or a bona fide purchaser of property for value under state law in the commencement of the case. And they give that trustee, most importantly, when we speak about avoidance actions, the right to control and assert individual creditor claims under state law to avoid transfers as intentionally or constructively fraudulent, so long as a creditor actually exists in a relevant time period for clawback to assert such claims absent bankruptcy. The transfers that are subject to avoidance here are either actually fraudulent to creditors, in that it is the debtor's intention to make a transfer in order to hinder collection efforts, or they're not supported by fair or reasonably equivalent value. Such value can include the incurrence of antecedent debt. This right of control is to be exercised in bankruptcy by estate fiduciaries, like a trustee or a debtor in possession in a Chapter 11 acting as a trustee, for the benefit of general unsecured creditors, entities that do not have direct property rights in the assets of the debtor or in the estate. Now, these avoidance powers also importantly include the right to assert preference claims. And this is a specific bankruptcy law creation, although there are state law analogs, that is designed to remedy diminution of the estate prior to filing by creditors' exercise of market power over a financially wounded debtor. They focus for non-insider creditors on transfers of property that occur within 90 days prior to the commencement of the case, or in the case of insiders, entities that exercise dominion and control over a debtor, the year prior. What preferences are focused on is repatriating value that derives from transfers forced out of a debtor that aren't supported by the giving of new trade credit, or that are not in the ordinary course of the debtor's business. And the preference power is designed in the US law primarily to ameliorate aggressive collection efforts on antecedent debts. This is an important distinction between the preference power and fraudulent transfer avoidance that can be initiated by a trustee. Both powers are designed to realize on the important policy of ensuring equality of distribution to creditors. And so fiduciaries for creditors in the estate, primarily in the first instance for the estate, entities exercising the power of a trustee, use these avoiding powers to maximize collective value, repatriating property and value transferred or encumbered as a debtor fails and or becomes insolvent or undercapitalized. They are rights that in the case of fraudulent transfer claims originally belong to individual creditors and are controlled to make sure that we do not have a race to the courthouse. And at the same time, they build the debtor's estate so that there's a maximum amount of residual value for the residual risk takers, usually in American bankruptcy, general unsecured creditors. It's important to reflect that an avoidance power is not a debtor asset per se. The proceeds of an avoidance action are. What they are, in fact, are prerogatives that are given by the bankruptcy law to estate fiduciaries and representatives. And so they are generally not saleable, and they are generally not supposed to be subjected to the liens of senior creditors. Now, Robert is going to speak in greater depth to those subtleties, but he is also about to give us a more fulsome technical explanation of preferences and fraudulent transfers under the U.S. bankruptcy law. Robert?
Thank you, Michael.
Robert, before you start, can I just make one comment? I think the backdrop that Michael provided was been very, very useful in understanding in an overarching way how it works. But I think some of the things that the audience would like to hear from you as nuts and bolts would be who actually files the application in the US, whose decision is it actually, and also to some extent, is it an obligatory requirement, or is it something which is done based on a request and not as a matter of factly? Some of these things, if you could cover as you make your presentation. Thank you.
I certainly will. Thank you. Good evening or good morning, as the case may be, everybody. My name is Robert Feinstein. I'm the managing partner of the New York office of PACHULSKI, STANG, ZIEHL, and Jones. You may know my partner, Deborah Grasgreen, who's the president of the III. Just to introduce the Zoom background behind me, that is the United States Bankruptcy Court for the Southern District of New York. It is the place of business of a number of III members, including the Honorable Martin Glenn, who I saw as observing today, and Alan Gropper, and of course, the late Honorable Burton Liflin, who's really one of the founders of really cross-border insolvency and the development of many aspects of international cross-border law. So I'd like to take 5 minutes and discuss over 200 years of history of the development of avoidance matters, but of course I can't do that. So I'm going to limit myself to the last 125 years. The Bankruptcy Act of 1898 was, I believe, the first statute to include preferences. Fraudulent transfers actually go back centuries. The renowned source of fraudulent transfer law dates back to 1571. The statute of 13 Elizabeth in England was the first known statute to provide for the avoidance of transfers that were intended to hinder, delay, and defraud creditors. So that intentional fraudulent transfer has always been part of the law, but what's developed over time and has now been codified in the U.S. Bankruptcy Code is the concept of a constructive fraudulent transfer, which is different from an intentional fraudulent transfer in that the mens rea, the mindset of the transfer is irrelevant. If there's a transfer that is made for less than a reasonably equivalent value by an entity or person while they are in financial distress, either insolvent or undercapitalized or unable to meet their debts, that is avoidable as a constructive fraudulent transfer. The reachback period for constructive fraudulent transfers and actual fraudulent transfers is set forth in the Bankruptcy Code, but there's an important interplay between federal law in the U.S. and state law, in that the operative provisions of the Bankruptcy Code dealing with avoidance of transactions there are 3 sections, Section 544, 547, and 548. Let me begin with the easy one, 548, which is the federal statutory enactment of fraudulent transfer, of actual and constructive fraudulent transfer. 547, which we'll talk about more in depth because I know it's new in India, is preferences. And then 544 is an interesting provision in that it allows the trustee, or if it's a debtor in possession acting in the place in a Chapter 11, the trustee may avoid transactions that are avoidable under state law. So 544 incorporates state fraudulent transfer statutes, and indeed all 50 states have one form or another of a fraudulent transfer statute. Very few states have preference statutes, but fraudulent transfer is quite common. And while we look at, maybe from the outside looking in at the United States as a monolithic bankruptcy system, in fact, the incorporation of state law through 544, the fact that there are not consistent fraudulent transfer laws among the states creates for some interesting issues and confusion sometimes. But I do want to talk more about preferences, because preferences really weren't part of the statutory scheme until 1898. And the basic elements of a preference claim is a transfer that is made on account of an antecedent debt by a debtor while they're insolvent that would allow the creditor to receive more than they would receive in a Chapter 7 liquidation. So there are quite a number of defenses to preferences that are set forth in the statute. Interesting, and this may be one reason why preference litigation is not particularly popular in the United States. There's no obligation on the plaintiff's part, whether it's the trustee or debtor in possession or creditors committee. There's no obligation on the plaintiff's part to allege the absence of affirmative defenses. And that's typical in litigation. You make out your case and the defendant can set forth affirmative defenses. But because there are so many affirmative defenses to preferences in the US statute, often the notion that there was simply a transfer in the 90 days does not mean that there's really an actionable, viable claim, because the defenses are quite robust. And let me just deal with them one by one. The first to discuss, which you may well be familiar with, is the ordinary course of business defense. If a transfer is made consistent with past practice, both between the debtor and the payee, and also consistent with industry practice, then there'll be a defense to the payment that allowed somebody to receive more in that 90-day window than they would get in a liquidation. And the ordinary course defense is very fact-specific. There is both an objective and a subjective element to it. Objectively, is this consistent with practice in the industry? And then subjectively, is this consistent with the practice between the payor and the payee? So for example, if a vendor to a debtor in bankruptcy was pressuring the debtor before the bankruptcy, you've got to pay me or I'm not going to deliver more goods, and a payment is made, that kind of pressure, the timing of the payment, that may destroy an ordinary course of business defense. Another defense is the contemporaneous exchange for value. Now, there is also a provision that says a purchase money security interest is also immune from preference attack. And both of those provisions basically look at whether or not the estate has been depleted by the transfer. And in each case, in contemporaneous exchange, there is a payment being made, but the estate is also receiving something. So there is no net negative, no outflow of assets from the estate. And that's the basis for the ordinary course of business defense. Another defense that's very important in the US and also easy to measure is the subsequent new value defense. So if a vendor sells goods to a debtor and receives payment on 70 days before the bankruptcy, but then on day 40 before the bankruptcy, the vendor ships more goods to the debtor. The value of that shipment is going to be treated as an affirmative defense, an offset to the preference claim. The theory behind this is policy matter, is that you want to encourage people to continue to do business with distressed companies. So you don't want to discourage them from continuing to ship. And in fact, this rewards them by allowing for a defense where a vendor has continued to extend credit, notwithstanding that they have gone unpaid and that the debtor is in distress. So these are also very fact-specific defenses, but easy to measure, because dollar for dollar, and any new shipment of goods on credit will be considered a defense. There is a split of authority in the US whether the new value has to go unpaid or whether you get credit for giving new value where you've been paid. And again, there's a lot of splits of authority on many preference issues. It produces lots and lots of litigation in the US. So let me address Sumant's question, who can bring the preference? So the statute, if you read it, says the trustee may avoid preferences and fraudulent transfers. In reality, typical Chapter 11 case, the default is the debtor is a debtor in possession. So the debtor in possession, the incumbent management, will be the persons in the first instance to decide whether or not to bring claims. And it's somewhat awkward sometimes, because incumbent management may be called upon to sue people with whom they've been doing business pre-bankruptcy for years and years. So there may be reluctance on the part of the debtor in possession to bring the claims. Similarly, with fraudulent transfers and other insider transactions, you can't always count on the debtor in possession to be impartial and to bring the claims. So what happens if the debtor is unwilling or incapable? That's where official creditors committees in the US can step in and seek standing to prosecute the claims, have to get the blessing of the court to do that. And always, you know, whether in Chapter 7 or Chapter 11, if an actual trustee is appointed to displace the debtor in possession, then the trustee will be the one to bring the claims. How much time do they have? The statute provides for 2 years from the petition date in Chapter 11 to bring avoidance claims. People are always looking at that 2-year period because the look back period could be years under state fraudulent transfer laws. The look back period is 4 years, but you start a clock ticking when the case files. You have to bring claims within 2 years or they'll be barred. In terms of the look back period, again, there's a difference in the US law for preferences between insiders and outsiders. It's 90 days for general outside creditors, and the look back period is 1 year. I understand that in Indian law, those are longer periods, and people will debate, I suppose, what is the appropriate look back period for preferences. But I think the idea behind the 90-day period is that the presumption is that's when the pressure may really mount on a debtor to start making payments as they're in financial distress. And that's why, again, the idea of pressuring creditors to make that payment is a relevant evidentiary point in terms of litigating these matters. So I'm gonna stop there, as I know we have a lot to cover, but there's your basic nuts and bolts. Thank you.
Well, thank you so much, Robert. That was very helpful. And I'm going to go to Martha now. And maybe let me just start by asking you a more pointed question. And that's something which Dr. Sau also mentioned very briefly in his address. And I have about 8 to 10 questions already from the audience on that, which is that can an avoidance petition or an action be separated from the insolvency proceeding and go on separately to find its own fate? Or are they coterminous with the insolvency proceeding? As Dr. Sau mentioned, that we have a Delhi High Court order which says that they're coterminous, and neither the court nor the insolvency professional has jurisdiction that survives to continue with the proceedings once the process comes to an end on the insolvency. How does it work in India? Because that's sort of a tricky part for us, because we have very tight timelines on the insolvency. While avoidance applications can be quite complex, they may have complex issues that may take time for the court to decide. And that therefore this continues to be a debate in India at the moment. So it'll be good to hear from you. How does that work in the US?
Sure, thank you very much. And first, good evening to everybody. I'm Maya ZERJAL FINK. I'm a partner at Arnold & Porter Case Shoulder, and it's a real pleasure to be with more than 350 people today. So I will build on what Michael and Robert said and mention that, first of all, there is this 2-year period to bring all of these claims. But what is crucially important is that these claims belong to the debtor's estate. Like Michael and Robert said, they are intended to increase the estate. And therefore, once you come to the end of a restructuring, if we're just focusing on Chapter 11 for now, the idea is that you distribute the assets and provide a fresh start to the debtor. So in terms of assets, it wouldn't really make sense if these claims, and sometimes they're quite valuable, would just be transferred to a different proceeding. So initially the jurisdiction is within the bankruptcy court, but the key information you're looking for is that if during the bankruptcy case, these actions are not either prosecuted, and in the vast majority of cases, they will be either settled or mediated or else, otherwise resolved without an actual trial, because it does become a trial. Like Robert said, oftentimes it's very factually intensive, so it would take a long time to prosecute these. So what will happen is the plan will distribute the assets of the debtors, and not to just distinguish these claims, those will oftentimes get transferred into something that's called a litigation trust. It's a trust that is established by the bankruptcy plan. It is administered pursuant to a trust agreement that is approved by the bankruptcy court. And more often than not, the creditors or somebody appointed by the creditors, usually the professionals that represent the official creditors committee, or somebody else appointed, would then be appointed to pursue these causes of action after the plan is confirmed, after there is a reorganized debtor. And what happens is that the interest in this litigation trust is not then vested in the reorganized debtor usually, but the interests are then transferred to creditors. More often, it could be secured creditors, it could be unsecured creditors. But the point is that this litigation then, after the plan is already confirmed, can take years. And it's also a different mindset because there is usually a certain fund set aside to fund the litigation. But there's also implications of, sometimes a litigation funder can come in if the claims are interesting. There's a different type of administration, but it becomes, separate from the bankrupt entity that becomes a new reorganized entity essentially continues. It's just that with the plan, these causes of action survive. It also means that these entities that are the targets will not be released under the plan. So there's really two ways of dealing with it. At the beginning of the case, like Robert said, the debtor will have the initial obligation to investigate these claims. In the US, the debtor is required to file statements of financial affairs and schedules of assets and liabilities. And there is actually a specific schedule where you're supposed to list out the payments in the last 90 days and a year, like Robert mentioned, in the sense of preferences. So everybody can see what these payments are. That's required. And there's also a requirement for fraudulent transfer to investigate them. If the debtor does not, like Robert said, the official committee will step in. So in the majority of cases, it will either get settled and somehow embedded in the plan. Either the targets will provide value to the estate in exchange of a release so that there's a clean slate for everybody, or if there's no time or these are valuable assets and sometimes the only recovery for unsecured creditors, they get transferred to a litigation trust.
Well, thank you so much, Mary. I mean, that's very, very helpful because that's how, based on international best practices, how the market had approached the entire resolution plan process vis-a-vis avoidance transactions till that judgment came from the High Court, which is that the resolution professional continued to draw authority to pursue after having filed, even though the plan may have been approved in the meantime. And also there would be an arrangement within the plan as to what would be the treatment provided to the receivables from the avoidance transaction as and when they come. And also there would be a provision for meeting the cost of that. And of course, the end beneficiaries would be the creditors, whether they are secured or unsecured would depend on the dynamics of each case. And I think that's something which I see is how it works in the US, as I hear you. So would it be right to say that the trustee would therefore continue to draw authority to pursue these matters beyond the date of the resolution plan approval? Would that be the right understanding? Yeah.
Somewhat. So the bankruptcy court, right, which would be the equivalent of the adjudicating authority here, would maintain the primary subject matter jurisdiction to adjudicate these actions. In reality, within the bankruptcy case, there are various proceedings. So there can be a contested proceedings, which is really motion practice. You file a motion, there's an objection, there's a hearing, it's much faster. These matters are usually adjudicated pursuant to adversary proceedings, which are essentially like a mini trial. The bankruptcy code really does incorporate the rules of civil procedure into bankruptcy cases. They're a little faster, but the answer to your question is the bankruptcy court will maintain jurisdiction to adjudicate them. As to who prosecutes them, there will be a trustee appointed to the trust. So the debtor, if we're talking about Chapter 11, right, and you think about management, that will be completely separated. There will be a third party that steps in to manage the litigation trust, if that makes sense.
If I could jump in, I think it's important to note that the liquidating trustee is different than the Chapter 7 trustee or the Chapter 11 trustee that are appointed by the Office of the United States Trustee. The litigation trustee is an individual appointed pursuant to a plan of reorganization to serve as the successor to the debtor for purposes of claims. 1123 of the Bankruptcy Code allows claims to be conveyed to a successor. Now, that's different than selling the avoidance actions to a third party. It's an important distinction because, as Michael noted, these are not assets of the debtor. These are statutory avoiding powers that belong to a trustee, and a debtor, while it's cloaked with the mantle of debtor in possession, gets to exercise the trustee's powers. But upon confirmation of a plan, the debtor in possession is no more. There is no Chapter 7 or Chapter 11 trustee because the company has emerged from bankruptcy, but you do get this private trustee, if you will, who is anointed under the plan to prosecute the claims. There are instances, and they're rare, where avoidance actions, where parties attempt to sell them. Now, one way that they're sold is in an asset sale. A third party comes in and buys all the assets of the debtor. It's not uncommon to see them also buy the avoidance actions accompanied by a covenant not to sue on the avoidance actions. Why would a buyer want to proceed that way? If you're buying an operating business, you don't want the vendors to that business to be sued. Going forward, you want them to be happy customers or happy suppliers. There are instances. I had one case 2 years ago of the Barney's department store case where a liquidator came in and offered to buy the avoidance actions flat out and to keep the proceeds. And this is anathema to U.S. practice, I think, in many respects. First of all, these are not assets to be sold. Second, the beneficiaries of avoidance actions should be the general unsecured creditors, not a third-party purchaser. And this is very interesting in the run-up to the preparation of this panel. We were speaking with SUMANT about who benefits from these avoidance actions in the U.S. law, and also now that preferences are part of the Indian statute. And the SUMANT explained it to me. It's very interesting that the advent of preferences in the Indian statute was really at the instance of secured creditors who felt that unsecured creditors, vendors, and the like were getting off easy for receiving these payments in the run-up to bankruptcy. And so the secured creditors are the presumed beneficiaries of the prosecution of avoidance actions under the Indian Insolvency Law. The opposite is true in the US, which is it is anathema to, as do a lot of creditors committee work, anathema to see secured creditors receive a lien on avoidance actions and receive the proceeds of avoidance actions, because the statute was intended, as Michael noted, to provide for equality of distribution among unsecured creditors. So giving the proceeds of avoidance actions to secured creditors is the worst possible outcome for unsecured creditors in the US. As it is, times are very hard. Unsecured creditors are receiving very little cents on the dollar, but then insult to injury if they now have to give back money to the estate as a preference and they don't get the share in it because all the proceeds would go to secured creditors. So we have very different backdrops to our preference system in the US versus India.
Well, thank you so much for that, Robert. I want to go back to Maya again, because I had one clarification from your earlier comments, Maya, and one question as well. The clarification is more with regard to the trust account that is open, in which eventually the proceeds will go after the trial is over, and if there are any receivables. Is that a standalone trust account maintained for that particular avoidance proceeding, or is it a general account that is maintained, and who maintains that? That's the clarification question. And two, who actually, that's more of a question, who actually meets the cost of the avoidance action? And whose obligation is it to actually provide for the costs? So Maya, over to you.
Sure. So to your first question, I suppose the answer depends whether the money comes in during a Chapter 11 case, so before there's a plan confirmed and the causes of action are transferred to a litigation trust. If it's during the case, I don't know that it needs to be in a particular account. It's just assets that come in to a debtor's account. I mean, certainly if the committee is pursuing them, there can be an arrangement that it's held in a separate account to then be distributed to the unsecured creditors, like Robert said. If it's a litigation trust that operates after the reorganization is completed, then there is certainly a separate account, and then the trustee, and like Robert said, it's a separate private trustee, will distribute the proceeds from that particular account in accordance with the trust agreement. There could be varying provisions. Usually it will say that there will be quarterly distributions or whenever, or there could be distributions whenever proceeds come in, but it's essentially governed pursuant to the litigation trust agreement. So that's a regular trust. And I'm sorry, your second question was?
What was about the costs? Who actually bears the costs? Yeah.
Sure. So again, initially, when a Chapter 11 case is started, the debtor, bears the burden, I suppose, to put together the schedules and to conduct an initial investigation. Like we said before, if there is derivative standing that is granted, usually to the creditors committee, that would be the committee. The common factor is that these investigations are generally conducted by state professionals, so by professionals that are hired and approved by the bankruptcy court. So the short answer is the cost will be borne by the bankruptcy estate. Those costs in the US are administrative expenses, so they have to be paid in full in cash for a plan to be confirmed. If we're talking about a litigation trust that is established pursuant to a plan and so, continues after the bankruptcy, then usually there is some funding that is set aside in the plan itself that, assumes that it will be enough to pay off. Sometimes there's contingency counsel handled, but, there is some financing provision, because at that point it would not, the cost would not be treated the same way as it would be during a Chapter 11 case. And I guess on that point, I just wanted to point out that, there can be a lot of valuable claims. There are certainly always claims that can be investigated, or an investigation is often or always pursued. But these claims are not always pursued, if you will. So the reason why there is a settlement oftentimes is that what both the debtor but also the creditors committee employ is something called the cost benefit analysis. So like Robert said, if this is an operating business that wants to continue operating, first of all, you're probably not going to sue your key suppliers, right? Because first of all, you want to continue doing business with them. But second of all, like Robert said before, there's a lot of defenses, and going through all of the elements to actually prove a preference is really expensive. So that's one. Sometimes in cases, I don't think this is something we mentioned, especially when there's large LBOs or large intercompany transactions, takeovers and the like, in the billions of dollars it could be, it's very clear on its face that there are affiliate transactions that should be investigated because they're potentially the only source of recovery for unsecured creditors. Because if, from a creditors, so the creditors committee in the US is comprised only of unsecured creditors. The logic being that secured creditors have their security to protect them, and so they don't need a separate representation, although oftentimes they form ad hoc committees. So the best way for the unsecured creditors to increase their recovery is to, if you will, increase the pot for everybody, but especially for their bucket that sits under the secured creditors. So if there are very large transactions, the debtor often will say, well, let's say there's a parent company that might have, taken on debt, and the subsidiaries would pledge their assets or provide guarantees. That's a typical example, right? And the creditors might assert that they have not received reasonably equivalent value. What will happen is that the investigation will definitely take place, but if actions are actually pursued depends on whether the parties who would be sued are willing to come to the table and get to a settlement and usually provide some value in exchange for the releases, so that the litigation actually stops as of the plan. If the transactions are such that the creditors don't have too much faith that the debtor can independently investigate them, like Robert said, there's a lot of different incentives. So sometimes it's a little awkward to investigate your own parent company. There is, you can appoint an examiner. So an examiner is different than a Chapter 11 trustee. It's almost as an independent investigator, if you will. There were many fairly famous cases. I mean, one that comes to mind is the Caesars casinos, where there was a large LBO and everyone knew that some value will have to come from the parties that were doing the LBO. So an examiner was appointed, and the examiner took about a year to conduct its very thorough report. And as I understand it, it's somewhat similar than your report. It doesn't provide firm conclusions. So in other words, it doesn't say, there's a fraudulent transfer claim and it's worth $5 billion. It lays the ground for people then usually to come to the table and settle, which is exactly what happened in the case, or then for the appropriate parties to conduct the to actually pursue the actions, either in the Chapter 11 case or in a litigation trust.
Well, thank you so much, man. That again is very helpful, especially the example that you gave, and you spoke about the affiliates, and I want to go to Michael for that, but in a moment. Just have one more question for you, because in the US, usually going for litigation is not really something which is something which is done at the drop of the hat. I mean, there's always an effort to resolve the issues before litigating, and mediation therefore plays a very important role. And even I believe that the lawyers sitting across and mediating on behalf of the parties is very important. And how do you think that mediation is something which has been used in the avoidance actions as well, and have people actually settle as a part of those mediation rather than facing litigation or action? It'll be useful to know how it works in the US.
Absolutely. I mean, Michael and Robert were correct, but I think, the statistic generally in the US is that I think 4% of cases actually go to trial in general. And I don't think bankruptcy is any different, because when you conduct the cost-benefit analysis, it's extremely costly to go through all of the facts. And these are extremely highly factual issues. The other component is time. Like we said, there is a reason why you can transfer these assets to liquidation trust, because you will not be able to prosecute them to finality. And if there's appeals, never mind, it will just not be done in that amount of time. And so, on the other hand, the targets are highly incentivized, much like the debtor, to have a clean slate, to say, I get a full release under the plan, and I'm done with this. So this is why oftentimes in contentious cases, there's initial settlements going back and forth, and it might be at the 11th hour. And as we say, at the steps of the courthouse that is behind Robert there on the picture, but they're really incentivized to get this done, because I think what's a little unique about the US is that people are not shy about suing people, as I'm sure everybody knows. And so if you don't get a release, likelihood is somebody is going to come out of the woodwork and sue you after. And so nobody wants that. And this is why, I think it's just a bit, I guess, of a cultural thing where, if you're a former director or you're the parent company, it's much better to decide what the right amount of money is for you to have a peace of mind going forward.
Could I comment on just the garden variety preferences, the suits that would be brought on the 90-day payments to the vast universe of suppliers, for example, to a retail debtor? These are very rarely prosecuted during the pendency of the Chapter 11 case. As Maya noted, first of all, the debtor does not want to sue its vendors and its creditors when it's looking for their support. It's a very unpopular thing to do. Second, there's very little trial practice in the preference area, because the vast majority of these cases settle, some through the use of mediation and some through private negotiation. And the reason why I think these things settle is there is a fairly well-developed set of statutes and case law in the US about the various affirmative defenses, such that the parties can get together and really look at what is subsequent new value, what's ordinary course, to go from a starting point of $1,000 of 90-day payments down to a settlement for $125. And the reality is, because of the availability of affirmative defenses, the difference between the aggregate of payments made by the debtor in the 90-day window and what's actually actionable is enormous. I mean, our rule of thumb, we do a lot of trustee work, post-confirmation work, is that out of $10 million of payments in the 90-day window, the net preference recovery may be on the order of $500,000 to $1 million, because of the wide availability of these defenses. And again, the cost of litigating these is substantial, so parties are inclined to settle. Mediation is extensively used. We did the Circuit City Trust, for example. There were hundreds of vendors who had preference exposure. Maybe 10 cases made it to trial.
So I think it's really important, Sumant, when considering how avoidance actions impact American insolvency law, to sort of integrate what Maya and Robert are saying. Oftentimes, you look at principles of fraudulent transfer law, and from time to time preference law and aligned claims, to come up with the architecture, if you will, for a case solution in a complex Chapter 11. And then there are categories of avoidance actions that are essentially additive consideration to deals that are negotiated in the context of a plan. And there's a very specific tempo to our Chapter 11 practice. in the initial phases of Chapter 11, you're securing financing and you're ensuring that the company has a quote unquote soft landing in Chapter 11 and can operate both on a financial and a business level. And then you have a period of time where the advisors for the key stakeholders work to come up with a solution for the balance sheet and the value equation and negotiate a plan which rehabilitates the company, restructures its balance sheet, and tries as best one can, understanding these leverages that can be applied to the balance sheet by the avoidance action to resolve the largest and most important fraudulent transfer claims, preference claims, and the like that relate directly to the case solution. How do you reorganize the company? And as part of that, you may find that there is a pool of avoidance actions that will be additive consideration, usually for classes of unsecured creditors as part of this case solution. And the governors on this are the 2-year statute within which these actions need to be asserted properly from case commencement, as well as the reachbacks for avoidance, and this driving tempo to our practice about how we solve the big case problem and create, if you will, a tempo, like I said, and priorities as to what you address and how you address things. One of the reasons why you had an examiner's report in CSERS was because of A, the complexity of the problem and the centrality of the problem to the case solution. And so the judge there appointed the examiner because that report was going to create, if you will, at least a common set of facts and understandings around what happened in that leveraged buyout so that you could address the balance sheet issues that were inherent in the plan. And so there's a hierarchy, if you will, of need when you address avoidance actions in terms of what is important and when it's important and to whom it's important. And therein lies the art in what we do in Chapter 11 practice.
Well, thanks so much, Michael. I mean, I actually wanted to ask you about the group insolvency
Sure.
also, but and maybe you can touch upon that very briefly. But
sure.
Since we have a very little time, I mean, I'm conscious that there are a number of questions. Some of them are very interesting. I don't want to miss them. Some have already got answered in the process of your observations and comments, the three of you. But I just would put those 2 questions also to you, and you could probably respond them. One
Sure.
of the questions that came in: are there specialized professionals in this field? Are there those who actually just do avoidance and they have high skills on that?
Mm-hmm.
There is a question actually that has come from quite a few people. What are the general challenges that are faced by the trustee in identifying transactions and pursuing them? So if you could just also cover that as you talk also about the affiliate.
Sure.
Just to sort of
I will, as we say in the United States, put the pedal to the metal in addressing these questions. Yes, there are professionals that specialize in litigating avoidance actions. And again, there will be specific legal practices that have a reputation for bringing on these litigations on a contingent basis, including very complex challenges to capital structures. There are firms that have formed themselves around a very specifically designed, almost algorithmic approach to litigating preference claims. So there are actual specialty law firms that will create programs which are designed to generate efficient value from trade preferences. And so, yes, there's a high degree of specialization that has arisen, and these specialists are expert among
Michael, sorry for interrupting you. Michael, sorry for interrupting you, but do these professionals also step in during the time when the trustee is examining these transactions?
Sure. Yeah. Sure. So very often, I'll just use the example of the specialized trade preference program firm. Those folks will offer to provide analytic services as an entree to obtaining a mandate. So they'll look at the scheduled statement of financial affairs and general ledger of a debtor to get a sense of where and if there's a significant amount of value, and they'll provide, whether it's a creditors committee or a debtor, with a report which will demonstrate whether the preferences themselves have inherent value that can be obtained. And that can help with some of the decision-making that Robert referred to around sales. So for example, if one of those folks comes in and does an analysis and it shows a negative cost benefit analysis, to take Maya's rubric around trade preferences, then it is quite possible, in essence, to sell the right, if you will, to release or to otherwise covenant not to pursue those actions to a buyer. In essence, it's a final disposition of those actions in the context of the sale approval. So these folks can provide that sort of services. There are specific firms that look at highly complex litigation claims and are known for taking contingent fees. Those folks may also be pre-consulted about major avoidance actions by estate professionals who are relying on the cash flow of the debtor and need to come up with a solution. And the complexity there is significant. So I won't burden our discussion further with that. I think you'd also asked about, and I think this is really important to all of you in India, how one goes about identifying these transfers and determining them. And it goes back to Maya's point about the blue sky information that's required by American bankruptcy law. It's very important to understand that trustees and debtors in possessions are fiduciaries for the estate, and therefore have requirements to create access to information and to marshal information. And debtors are required to create a bankruptcy balance sheet, if you will, evidenced by detailed schedules of their assets and liabilities, and a statement of financial affairs which provides at least an initial set of disclosures relating to transfers that have been made, where assets are located, what actions may have occurred pre-petition that would have caused a monetization event for a creditor. Between these two imperatives, the requirement of the debtor to disclose information about its assets and liabilities, and the trustee requirement to marshal information, you create a set of information that will be accessed by committee professionals, by specialized professionals like the ones that we're talking about, to further investigate and test these transfers, again, at a time that is appropriate and sensitive to the hierarchy of needs in the case. And so that may happen through an examination like you saw in Caesars at the very heart and fulcrum of the reorganization. It may happen in the context of the run-up to and the post-plan examination, et cetera, before you get to your statute. And it's the central basis for this is the duty that the debtor and its fiduciaries have to marshal and preserve information and to disclose it in certain ways.
If I could just jump in for a second. First of all, I'd be remiss if I didn't say that my firm is one of those firms that does have a specialty group. We have a post-confirmation group that does nothing but bring preference claims and claims objections post-confirmation. But I did want to point out just how unpopular preference litigation is in the US. That, you know, from a general unsecured creditor standpoint, again, if your recovery is going to be very minimal in a case because the debtor's assets are all leaned up, it is insult to injury to be sued on a preference. And, you know, generally people think about bankruptcy in Chapter 11 in particular as a way to revitalize a debtor, to reorganize a business and save jobs, not about suing people who were doing business with the debtor in the past. So often, even though unsecured creditors are typically the beneficiaries of preference recoveries, it's often the creditors committee that's looking to bury them, to make sure that these go away that they're sold with a covenant not to sue, or they're released under a plan. But there is a responsibility on the part of the bankruptcy professionals, by the debtor and the committee, to diligence the existence of these claims, to see what's out there in the way of 90-day payments, and also to look at what available defenses are there, because the actionable preferences are vastly smaller than the 90-day payments. But judges typically will not allow the reference claims to be released without state fiduciaries at least looking to the facts to make sure that there's no aberrational large preference claims that are being given away for no consideration.
And I will also add that there are tools under the bankruptcy rules that enable broad investigations that are broader in scope than you would have in typical civil discovery. Sumant, before we run into the end of our programming, do you want me to touch upon the groups of related debtors and their surface to avoidance powers, or do you want to address?
Just after I've asked my one question, which is more, we heard that this is a fiduciary responsibility to file the avoidance action. Are there any disincentives or incentives associated with that? I mean, disincentives means if there is a failure to perform that fiduciary duty, are there any consequences? And similarly, if you do discharge that responsibility, are there any stars which are placed on your shoulders?
So I think it all goes back to leverage. There is no obligation to start these actions. It all goes back to the cost-benefit analysis. Like Michael was saying, this can be the central issue in a case, like it was in Caesars, but there's a lot of cases where these actions are not really worth much. I just wrapped up a case last week where these actions came up a week before confirmation by the committee, solely to say, you know, we can try to prosecute these actions against the secured lenders to extract more value for ourselves. And this led to a 2-day negotiation where ultimately the secured lenders agreed to increase the recovery for unsecureds for, you know, X amount. And it was done in a week. Of course, the committee took more time to pursue their investigation, but the incentive is solely something that, you know, it solely increases your leverage. So in other words, the committee, right, who is usually really incentivized to make sure that the debtor did not leave any stone unturned, might come to the conclusion that it's not worth prosecuting, also because derivative standing is not granted easily. So a committee would have to show, first of all, that the debtor unjustifiably refused to pursue these actions. And that in itself is a factual determination. So the incentive lies simply within whether you decide that pursuing these actions is actually likely to increase your recovery. If it's not that, it's oftentimes just like Michael and Robert said, it has to be disclosed. If nothing else, there is a disclosure statement that is filed with the plan. In the US, a disclosure statement is akin to an offering memorandum. So it's, you know, it's an official document that describes the assets of the debtor, that explains what will happen with the debtor. And so if nothing else, there has to be some mention of the investigation that has to be done, or it's, you know, it's included there, or the judge will not let you just go away without any kind of mention of these actions. Yeah. But there's no, if you will, no reward, if you will.
Yeah, I understand. And we have an equivalent of the disclosure statement in the form of Form H that is required to be filed, and there is an obligation to disclose in that the status of the avoidance matter. So it's quite similar to what you have in the US. And the incentive that I see for insolvency professionals in India is that you get more and more cases, and you get better cases if you've been diligent, if you file something, of course, something that deserves to be filed and pursued it efficiently. More and more lenders would opt for you.
Well, for us in the US, understanding the leverage that avoidance power can create on a bankruptcy balance sheet is incredibly important to us charting a strategic course for our clients, whether in defense or in the search for value. And so for us, it's a critical area of analysis, particularly when we're talking about those things which have a significant impact on the case, Sumant?
Yeah, so I know, Michael, I mean, we've just got 4 minutes left, and unfortunately, we might just have to sort of leave the group insolvency part for another time. And also something that we had as a surprise as a last slide to talk about how it might work in the US in the context of a specific, I don't think we would have the luxury of doing that in the next 4 minutes. And I wanted to give an opportunity to Dr. SAHOO at this moment. Dr. SAHOO, you've been listening. Would you have any comment to make? I mean, we have just about 4 minutes to wrap up. Would you want to say, make any comments or observation?
Not really. As you rightly told, we should have the IPs should be carrying certain values, in the sense that the market should prefer to hire an IP who has a track record of realizing value through avoidance transactions. And in fact, I find this kind of in respect of valuation professions, in fact, I have found in the US context that there are a set of valuers who are preferred by market and who are on average, I'm told that the members of a particular valuer organization is on average paid higher by about 50% over the average payments made to other valuers in the country. So that kind of a value proposition, if insolvency professionals can bring in, and the kind of benefits I talked earlier, that today we waste a lot of time when an application is filed for admission, but the promoters or directors keep on resisting on some ground or other. At times it lingers for a year. But if the directors are now aware that during this period they have a delay, the insolvency should have been actually commenced 1 year ago, but it actually commenced after 1 year. And whatever loss that has happened to creditors during this period of 1 year, the directors will be personal liable. And this IP brings out in every resolution process. Then no director, no promoter will ever fight when they have no merit really. They will never fight to delay the process just for the sake of a delay. So therefore, actually, as you also mentioned earlier, IPG have insolvency professionals have a critical role in following up avoidance transactions. And that is all I would like to say.
Well, thank you so much. And I think it says a lot, because I also mentioned that in the beginning that while of course we've seen almost in every case avoidance applications being filed, but I have no hesitation in saying that most of the cases are half-hearted attempt. It's just a tick box approach, but that is not what it is meant to be. It has to be an exercise that is aimed at maximizing the value for the creditors. And that's a big service that an insolvency professional does by contributing in this area. So one has to do it. It will always come at a cost. It won't be easy. It won't be a cakewalk. There will be resistance. There will be pushback. But that's where the skills of the insolvency professionals have to come in. Now, I know there are 3-4 questions at least, Michael, that unfortunately we have not been able to pass on to you on related party transactions, especially in the context of group companies. But unfortunately, it's 7 p.m. here, and we will have to leave it.
We're happy to come back, Sumant. We're happy to discuss these issues in greater depth and greater specificity. This is an overview.
Yes, absolutely.
We're happy to continue the work as you need us to continue it.
Yes, absolutely. And as we were discussing that, maybe we could also have another level of engagement with the IBBI and discuss some specific areas where we could do just with the IBBI or Dr. SAHOO's team on more specific areas where we could amplify.
Absolutely.
And of course, we can come back to the audience again. But for the audience whose questions I could not take today, I just want to mention that we have another similar panel discussion on the UK system, which is on Friday, 3:30 p.m. India time, again for 1.5 hours. And I promise you that I will definitely make sure that we give adequate time on the related party transactions on the avoidance side on that. And of course, on the US side, we will continue to engage on this and come back again. I'd like to thank you all, Michael, Robert, Mia, very much for your time today and the time that you gave for the preparations. It was excellent. I mean, 2 calls, detailed calls that we had on the preparation shows your determination and commitment to help us and work with us on this. And thank you, Dr. SAHOO, for this opportunity, which we are hoping that we will continue to build on going forward. And I also want to thank the team at III, starting from Anika and her colleagues, all of those who made it happen today. Thank you so much. And thank you, of course, our participants. We started with 426. We touched 426 at one point in time, which is a huge number. And we still have about 300, over 300 still listening to us. And I do hope that they have enjoyed this conversation. And thank you so much for taking out the time this afternoon to be with us. Thank you, everyone, again, and have a good evening or a good day, as the case may be, please. Thank you.
Many thanks.
Thank you very much.
Thank you all on behalf of IBBI. Thank you.